May it please the court, Andrew Pluggy on behalf of the appellant, Ms. Goldberg. And Your Honor, before I begin, I'd like to reserve 5 minutes for rebuttal.
Okay.
We're here today on an appeal from a final judgment as it pertains to a order denying plaintiff's motion for a new trial. Specifically, we're asking this court to overturn the final judgment and return this case to the trial court for 2 reasons cited in our briefs. The first is it is unclear that the proper legal standard was applied in denying the plaintiff's motion for a new trial. And if the proper standard was applied, the evidence or the verdict is against the manifest weight of the evidence, and a new trial ought to have been granted. Just procedurally, after the verdict was rendered, the plaintiff finally filed a motion for a new trial. It was denied without hearing 9 days after the fact, and then a judgment was entered and an appeal was filed. I want to start on the first point. I do want to spend more time on the second point because I think it's more factually intensive. But the standard of review for our first argument is a de novo standard. And in this case, Your Honors, the trial court entered just a 1-page order denying the plaintiff's motion for a new trial, stating they've reviewed the record and fully advised on the premises and hereby orders that the motion is denied. Now, while we agree that the trial court is not under any obligation to use any sort of magic words or anything like that, it does need to make clear that the proper legal standard was applied here. And in the motion for new trial,
what law are you relying upon for that notion that the court has a positive, proactive duty to basically announce to the parties what standard it is applying?
well, Judge, I think the Lively court, it's that I understand that the trial court doesn't have any obligation to lay out actual reasons that it denied the motion. But
No, I'm taking you at your argument that it's just strictly the standard for a new trial. But in the cases that you've cited, what seems to happen is that not so much the court fails to make an announcement, but the court gives some indication that it's using the wrong standard, and from which the appellate court then has to get the course corrected. That's not really what happened here.
I appreciate that distinction, and I go on in my reply brief to kind of explain that a little further, Judge. In this case, like I said, the plaintiff's motion for a trial, it's cited to some testimony from the trial from the plaintiff and 2 of the doctors, and at least the deposition transcript, or the trial transcript from the plaintiff was not available to the court at the time. So our argument is, I have no doubt that the trial court reviewed the materials that were available to him at the time, but because they weren't able to review the entire argument or the entire transcripts that were argued in the new motion trial, that the standard they might have applied was sufficient. They could have just reviewed what was available to him and said this is sufficient.
Versus the judge had just heard the entire trial, not that several days earlier. And of course, the testimony in this trial was focused on this pre-existing accident and this pre-existing condition, which apparently the jury found to be important to their decision. I mean, it's yes, the transcript wasn't available, but certainly that judge's memory was available, and this trial really featured that pre-existing condition, that accident. Expert testimony by doctors who said there's no material difference between the MRIs from the 2014 accident to now. There was no change really. The only really issue I think you have is that there were $6,000 worth of medical expenses that were run up in determining whether anything was wrong with her or not. But it seems to me that the evidence was pretty overwhelmingly clear that she did not suffer really any injury that was notable in this most recent accident. And I think I think that spoke so strongly for itself. I mean, the judge's memory certainly would be good enough to remember that.
Sure. And I understand that, Your Honor, and I can transition to our second point, because I would like to address some of the things that you talked about with regards to the manifest weight of the evidence. Now, our only, kind of like Your Honor alluded to, our only arguments in this for the verdict being against the manifest weight of the evidence are that one, Ms. Goldberg suffered a cervical strain or sprain. Two, that she was entitled to the cost of her first 6 weeks, which is what Dr. Smith testified to.
Well, the problem with that is she wasn't forthcoming about that previous accident. I mean, she was evasive, didn't really volunteer much information, couldn't remember much information. So, there are cases that basically say when you're evasive and not forthcoming and not honest, that you're probably not going to get those expenses that you spent to determine that you in fact really didn't have an injury.
Well, Judge, and referring to Dr. Smith's testimony, he was asked about that, and Dr. Smith, his testimony was when he asked her about her prior neck injury. She acknowledged having a prior injury. She classified it as minor pain that she had in her neck. And the very next question that Dr. Smith was asked in that line of questioning was, well, she did tell you about the accident, though, correct, doctor? And he said yes, she did tell him. The meeting between her and Dr. Smith was 13 minutes, and she brought up the prior accident, the neck pain, and also Dr. Smith had her entire prior medical records.
So isn't this case very much like the one in Hernandez versus Gonzalez out of the 4th TCA? Basically, that court found that when there's evidence of pre-existing injury, to the extensive treatments, lack of candor, about all that is a basis to deny these expenses.
Sure.
And while it's not binding on us, it's certainly very persuasive.
Sure. And Judge, I don't think that Dr. Smith's testimony was that she was not candid with him. I don't think that there was any two distinctions. One, I don't think there was evidence that she lied about the prior incidents. She never once denied it happening. And two, Judge, and I believe in the Hernandez case and the cases cited by counsel in their briefs, all of those have to do with the accidents that were at issue in the case that was being argued. I mean, there's no evidence whatsoever in this case at all that she had ever once changed her story on what the accident was. She reported the accident, her first doctor's visit after this incident, and her neck pain, which was obviously the major issue in this trial, was she complained about that on day one when she went to the doctor. That's unlike Hernandez, because in Hernandez the contradictory statements were about the accident at issue.
Well, let me ask you a question, because with the CME now, Dr. Smith, one could interpret from his testimony, as I read it, was you asked, or your colleague asked below, was there an injury? And his opinion was really based on the premise that if you believe her, it's a cervical strain. But then he continued to say, it's related to motor vehicle accident, but I would expect her to have independent exercise, which doesn't cost a thing, rehab on her own, which doesn't cost a thing, and he didn't say that she needed any medication at all. So you're dealing with a client who has a prior herniation, either 4, 5, C5, 6, already has a clear herniation there, and genital changes and all that, and you can weaken segment below or above that she's not forthcoming about. Either that she has a selective memory, or she just forgets. I give her the benefit of the doubt. But see, you have a case where there's a low impact, very little property damage. Tough case to try for a client. It really is. But see, the jury has the benefit. And then the jury gets an instruction that says, you can believe or disbelieve all of this. That includes experts. So it seems to me they just decided to disbelieve it. And I don't think that's what we have to focus on. Actually, what occurred. Now we have a judge who tried. We all tried cases as lawyers and judge. We remember that 9 days is nothing. And 9 days does not alter your memory about a trial that you just had. So you have a tough case. And to say the manifest weight of the evidence. Really, the weight of the evidence was up to the jury. And it has to be clear and obvious. For us to find in your favor, and tell us how it's clear and obvious that this jury. Was either misled or they just got it wrong.
Sure, thank you, Your Honor. So two things. One, Dr. Smith's IME was taken, I think, 2.5 years-ish after after this incident occurred. So you're correct when you said, yeah, it's based on if we believe her and her candor with her initial, with her initial doctor, because by his own testimony,
But they don't last long. But did you retain Dr. Cove? How do you pronounce his name?
Kobe,
Yeah, did you retain him?
he was retained, yes, Judge.
Okay, when he saw her about as long as Smith.
Sure,
So that kind of is a wash.
right, no,
But
the point,
Cove also testified, she didn't tell me about the prior herniation.
Dr. Kobe had both images from before and after this incident, Judge.
Well, Kobe at transcript 254, I'm not aware of prior motor vehicle accident or herniation. Very important. So I mean, what I'm saying is, it's reasonable to infer that the jury goes, wait a second. You hired the expert who can render an opinion that a reasonable probability was not told by your client.
And Judge, we don't make any qualms about, we understand that the herniation that's not what we're here to argue today, Judge. We understand based on Dr. Kobe, Dr. Herbst, Dr. Fuller, all that testimony, we understand why a jury didn't find that the herniation was causally related. So that's not what we're here. We're just here to simply.
I'm sure you've tried enough cases where you know you can do an interrogatory verdict for past minutes. Have the jury vote on past minutes. That wasn't done here. It was an all or nothing. I find that to be significant to you.
Not in the sense that, even based on opposing counsel, trial counsel's, opposing statement, he acknowledged that around $6,000 was, I think, the number that he threw out. That based on Dr. Smith's testimony and Dr. Kobe's, and most importantly, the records from Dr. Rainey, which as was discussed through the trial, Ms. Goldberg was seeing him prior to this incident. And if you look at those prior records, there was no indication of a cervical strain until right after this incident. So Dr. Smith's testimony is simply a reflection of what is in the medical records from Dr. Rainey as it relates to Ms. Goldberg. And Dr. Kobe testified that chiropractic treatment that she received right after the accident was reasonably unrelated to this incident. And, the reason we came up to the 6 to 8 weeks that she should have been awarded is because that's, Dr. Smith's testimony focused that chiropractic treatment to, I believe his testimony was 4 to 6 weeks.
I didn't see it in the record, but can you remind me one way or another, did the plaintiff move for a directed verdict on the issue of the $6,000 or whatever it was?
No, there was no directed verdict.
Okay.
And neither was there an objection to the verdict form as well, right?
There was not, Judge, there was not a objection to the verdict form or the jury instructions. But Judge, we would argue that this case is very similar to the Hector versus Florida Farm Bureau case, which was a second DCA case where a denial of a new trial was reversed, where no issue of liability, uncontradicted evidence, and there was uncontradicted evidence of an injury. In that case, the court pointed to 4 key factors. The first, that the appellant was in no way negligent in the accident, that the jury determined that the appellee was negligent in causing the accident. In this case, there was no comparative issue, and prior to trial, the defendant admitted negligence. So those two problems are easily met. The uncontradicted testimony disclosed that the appellant suffered injuries as a result of this incident. Again, Judge, the only thing that we're here for is to talk about that cervical strain in his brain, and the records immediately prior to this car wreck indicate there was no cervical sprain that was listed on those medical records, and then there is the first visit afterwards. And again, that was Dr. Smith's testimony as well. I mean,
Just so you know, you're right at 15 minutes, but it's your time. You can.
that's fine, Judge. I can wrap up right now. But for these reasons, Your Honor, because between Dr. Smith and Dr. Rainey's and the plaintiff's testimony, we do think that this verdict was against the manifest way of the evidence, and yes, that we remanded.
Okay, thank you. You'll have 5 minutes when we return.
Thank you, Your Honor.
Please support. My name is Ezekiel Lugo, and I represent the Applees, Kathy Tam and David Tam.
A cervical sprain. That seems to be the most that happened to her. And we have expert testimony about what a cervical sprain is. Do you recall that testimony? What is a cervical sprain? I'm not asking you as a lawyer. I'm asking you as the lawyer who's read the transcript and knows what the doctor said a cervical sprain is.
I do not remember what the doctor said. Sprain is. On that issue, I believe that Judge Morris, you're going straight to the question about the diagnostic, the damages related to the diagnostic treatment, and maybe the 6 to 8 weeks that the doctors testify are required to treat the sprain. On that issue, Judge Morris, you pointed the Hernandez case, which said that, yes, there is case law allowing an award of initial diagnostic treatment, but there's an exception to that rule. And the 4th district cited a 2nd district case, State versus Rosario, where this court explained that where there's evidence, conflicting evidence of causation, evidence of pre-existing accident or injuries, and evidence of lack of candor of the patient to the doctors, the court can reject the argument for an award of the initial treatment and the diagnostic treatment. And those 3 factors are present here, and the court has already asked questions about those 3 factors. There was a 2014 accident that resulted in more substantial injuries than this accident. Photographs in this case show that the impact was minor. She did not go to the hospital right away. She did not receive treatment until several days later, when she went to the doctor that was already treating her for residual damages from the initial accident. Dr. Cobb, he testified on direct that the 2018 MRI showed injuries to C4, C5, and C5, C6. But on cross, he was clear that he was not alerted about the 2014 accident. He didn't have the 2014 MRI that was taken after that first accident. He had reviewed it by the time he did his cross-examination. And he said that the prior MRI shows she had a disc herniation in the same location, C4-5, C5-6. That testimony went to the heart of the causation issue. It's conflicting medical testimony that's relevant causation, and it's coming from the plaintiff's own expert. On closing, the defense highlighted Dr. Kobe's testimony repeatedly, and even gave a timestamp to the jury. The record shows a question from the jury on page 107 and 108, where the jury is asking for Kobe video start at 6:19:00 for 5 minutes. So the jury clearly paid attention to that part of the argument and keyed in. There's evidence in the record showing that the jury keyed in on the evidence of causation. So because there was evidence of pre-existing accident, pre-existing injuries and treatment, there was lack of candor to Dr. Kobe, who testified he treated her, and there's conflicting evidence of causation, even from just looking at the plaintiff's evidence itself. The exception that this court recognized in Rosario, that the Hernandez case went ahead and applied in that case, also applies here, and it supports what the trial judge did in denying the motion for new trial based on the manifest weight of the evidence, even if the court were to look only at the issue related to the initial treatment and the diagnostic treatment. So there is nothing in this record showing that Judge Ransberger abused his discretion. And he denied that motion for retrial. There's nothing in the record indicating that the judge failed to apply the correct standard or applied an incorrect standard. Judge Lucas, you pointed out that the cases opposing counsel is relying on were cases where there was an oral pronouncement, where there was an indication that the trial judge might have applied an incorrect standard. That's not present here. Judge Ransberger read the motion, sat through the trial, he lived the trial, he saw the witnesses, he was aware of the evidence. He could have relied on his personal memory, experience, whatever notes he had available. He was not required to have a hearing on that motion. And he could deny the motion without specific findings. The rule 1.530F requires findings only when the court is granted the motion for the trial. The argument that's being posited by opposing counsel would require either ignoring the rule or adding to case law something that the rule doesn't expressly require. So that argument fails.
The plaintiff places a lot of support on Dr. Smith's testimony on the cross at 34. He agrees that some treatment immediately after the motor vehicle accident was reasonable at about 6 weeks. That appears to be just on its face the definitive statement from the state. Was there evidence in the record where the jury could either disregard that or interpret it a different way? You got my question? Because they're relying on this in part by saying she's entitled to a past meds.
Dr.
And he's saying these past meds were reasonable and unreasonable degree of
But Dr. Smith couched his testimony, his opinion, that you noted.
Yeah.
When my opponent was up here speaking. On the fact that he was taking the plaintiff at her word. So when the expert says or testifies to that effect, the case law says that the jury is then free to disregard the experts, that whatever opinion the expert rendered that was based on that taking of the plaintiff testimony at her word, the jury can disregard it if there's evidence in the record that would undermine the plaintiff's credibility. And in this case, there was such evidence, and I already pointed it out as to the Dr. Kobe's testimony. So the evidence has to be clear, obvious, and undisputable on the issue of causation, which is what the jury answered. The jury answered question 1: what's the negligence of the defendants, the legal cost of the injuries to the plaintiffs? They said, no, this is a no causation verdict. This is not a zero damages verdict, as in the cases that they're citing. Those were cases where, in one case, the jury rendered a verdict finding that the negligence of the appellee was the legal cause of the accident, McLeod. So the jury found negligence and causation. When that's present and the verdict, the damages are zero, then that creates a different set of problems that is not present here. Here, there was enough evidence of causation that would support the jury's verdict. And before I sit down, the only other thing that I haven't heard discussed is the fact that this appeal is being presented to the court with a piecemeal transcripts of the jury trial. And that's important. Under Applegate, the appellant had the burden to show that they're there when the issue is a factual issue, like in this case, they're required to produce the entire trial transcript. That's not available here. So for that reason alone, without getting into any of the other issues, the court should affirm. And I will rest on, I will rely on the remainder of the arguments on race and breed, particularly there in this case that the court has already pointed out. So for all of these reasons, the appellants respectfully request that the court affirm the final judgment.
Thank you.
Thank
So 5 minutes.
Thank you, Raj. Thank you, Ms. Carter. I'm going to be brief. Just a few points I wanted to address that were brought up by counsel. First, there's been a lot of talk about this prior, and I understand why it's an ultimate big part of the trial. going to whether she suffered a new cervical sprain or strain in this second accident that we're here for. In their briefs, counsel relies a lot upon the prior records from Hess and Dr. Martinez. And, they cite to a Dr. Martinez record that talks about a chronic cervical strain. Well, then there was a 1.5 or 2 year gap in treatment that she stops treating altogether. And like I talked about initially, then she comes back to start seeing Dr. Rainey. And when she comes back, there's no cervical strain or sprain that was present. If that was still going on from the prior accident, it would have been in the records, but it wasn't. And again, I know the candor issue was brought up again. Again, Judge, that wasn't even an argument that was raised by defense trial counsel in the closing argument. There wasn't an issue that was raised by the trial counsel that she was dishonest with Dr. Smith. She was dishonest with Dr. Kobe. And regarding the MRIs that counsel brought up, again, not here to discuss the MRIs. I understand why the jury is well within their purview to come to that ruling regarding the herniations and permanency. I do want to actually cite to a case that was cited in counsel's brief, and that's the Wald case. And in the Wald case, which is a Florida Supreme Court case, it says a jury is not free to arbitrarily disregard undisputed medical evidence. And in this case, it is undisputed that there was at least a cervical strain that was suffered by Ms. Goldberg. None of the factors listed in Wald to disregard medical.
For the cervical sprain, I mean, while she was, as I recall, recommended some fairly benign treatment, she didn't undergo any of it, or at least not most of it.
The treatment that she didn't undergo were like the injections, Your Honor. She did undergo the initial conservative care.
That actually ties into something else related to that, which is that wouldn't the jury be free to disregard those damages insofar as they did have evidence before them that she had the previous injury, she had been prescribed a course of treatment, but she didn't really pursue that course of treatment either?
I would agree with that, Judge. If she came back when before this incident, when she started with the chiropractic care, if she was having the same injuries, if it was the same diagnoses that she had, when she stopped the treatment from the 2014 accident, I would agree with that, Judge. But because when she came back, it was none of the same diagnoses. And then she had a new cervical sprain after this car wreck. I would say that the jury, based on the testimony from her, from the doctors, should have at least awarded her those $6,000 and change that defense counsel talks about in his closing argument. The last topic I'll touch on that there's no evidence, even if the court finds that in trial defense counsel's closing argument, he makes a argument regarding to Ms. Goldberg's candor. The only thing that's being alleged is that her subjective memory or her subjective description of her neck pain from the 2014 accident, that was the only possible issue. There's nothing in the record at all that her story has changed from the accident. That's an issue in this case. That what happened changed, that her neck complaints changed, or her back complaints. There's no argument whatsoever that any of that changed with any of her doctors throughout the 4 years or 2 years between when the accident happened and when the trial occurred. And again, Judge, I think based on Dr. Smith's testimony, Dr. Rainey's records, and Dr. Kobe's testimony, it was against the manifest way of the evidence for them not to award at least those first 6 weeks of treatment along with diagnostic imaging because of the cervical strain. And we ask that this case be remanded for that issue alone.
Okay.
Thank you, Your Honor.
Thank you both very much. We appreciate your hard work and your briefs and your oral arguments, and they're very helpful to us in understanding this case.